Good morning, everybody. My name is Rebecca Kelly. I'm a commercial intellectual property and information technology partner at gunnercooke, and I'm going to be talking to you today as part of our 5 series about ways to be exit ready. We thought this was a very good topic to cover as we regularly come across companies that are looking to sell their businesses, whether that be via a share sale or an asset sale, and through the course of due diligence, we identify various areas that are not as we would expect them to be, and this can have a detrimental effect on the sale price offered to the seller. So we thought it would be helpful to go through 5 topics today as part of our 5 series, which give you indicators as business owners or as business managers of things you need to be alive to if you are wanting to ensure your company is ready for exit. Now, this doesn't have to be something that is happening imminently. We're not saying you're looking to be exit ready in the next 6 months. This might be a 5 or 10-year plans, but these are things to bear in the back of your mind that you can do to ensure that your business is absolutely in tip-top condition from a legal perspective when you want to exit. So the first area we're going to look at is key contracts. I have reviewed many businesses in a due diligence process, and when they tell me who their key customers are or where their standard terms and conditions are, we find that they are completely inappropriate or not reflecting the arrangements that they think they have in place. So the first area to concentrate on is your standard terms and conditions. A lot of companies simply don't have standard terms and conditions in place, or if they do, they have maybe borrowed them from somebody on the internet and copied them over. These are not appropriate. We would strongly recommend that you invest in getting properly drafted terms and conditions prepared for your business. These need to be properly drafted so that they're relevant to your business and focus on the key areas in your business where you often see problems. They need to be up to date and reflect current laws and current practices. And your staff need to be trained to use them. Staff training is a key area often overlooked. People pay to get standard terms and conditions prepared, but then they don't give their staff the basic training in how to use them. As a result, they may think that it's their standard terms and conditions which govern a relationship, but on closer inspection, it might be actually your customer's terms and conditions which govern your relationship. So staff training is critical, and that is something that we always offer to our clients whenever we're preparing terms and conditions for them. Another area to focus on as part of your key contracts is to look at who your key customers are. By identifying key customers in a business, you are identifying exactly who generates the vast majority of your revenue. In most companies, this is usually about 5 to 10 customers that generate the maximum revenue for that business. The contracts that you have in place with those customers must be in writing. I lose track of the number of times I find that a client will say to me, yes, we have 5 key customers, these are who they are, and we've got brilliant relationships with all of them. And I ask for a copy of their terms and say, well, we haven't got anything in writing, it's just a good old gentleman's agreement. If you disclose that to a potential buyer of your business, they would absolutely run a mile and would be asking for all manner of warranties in relation to those contracts, and you would see the sale price reduced as a result of the fact you have no contracts in writing with those key customers. It's also important that those key contracts reflect the commercial arrangements that you have in place with those customers. Quite often you will enter into fixed duration contracts with your customers in return for better pricing. There might be an exclusive arrangement, which again can trigger beneficial pricing. All of these elements need to be covered in the key contracts and reflected properly. And finally, another key area that would be focused on by any buyer would be to examine those contracts to see if there are any clauses that will be triggered and cause termination of those contracts on a change of control. So examples might be on on a change of control, the customer has the option to terminate the contract, or an assignment clause which prohibits assignment to another party without the consent of the customer. Those sorts of clauses need to be avoided if possible in any contract. So we would always recommend when drafting customer contracts that those clauses are omitted or certainly dealt with in a proper manner. And these same principles will apply to other key commercial contracts. So if you have any distributors that are key to your business, any agents, or you have any licensing arrangements in place, those should all be reflected. One thing I failed to say at the beginning of the presentation was that if anybody does have any questions, we're going to deal with those questions at the end of the seminar. So feel free, if you've got anything, jot it down on a note, and when we get to the end, there's a facility to chat with us, and we will receive questions and do our best to answer them today for you. So, in relation to key contracts, what your checklist should be and what you should always bear in mind are the following points. Have you got standard terms and conditions of sale in place? When were they last reviewed? If they are 10 years old, 5 years old, I would recommend that you get somebody to look at them to check that they're still relevant and up to date. Who are your key customers? Make sure you've got a list of key customers. Also consider carrying out credit checks regularly on those key customers to make sure that they're creditworthy. Have you got written contracts in place with those key customers? When were they last reviewed? Again, if they're more than 5 years old, it's likely that they are not up to date and don't reflect key commercial terms. Are your customer contracts reflective of your key commercial terms? And are there any other commercial contracts linked to your business that you need to consider keeping a list of and making sure they're properly documented and accord with the principles that we've already discussed? So the second point I wanted to talk to you today about is intellectual property. Intellectual property is becoming ever more an area of the business that is absolutely crucial, but often overlooked. And it can create value in businesses. Just because it's an intangible asset doesn't mean it cannot be reflected in a balance sheet. So you really need to be alive to what intellectual property exists in your business. This can include registered intellectual property, such as registered trademarks, patents, registered design rights, or it can include unregistered intellectual property, such as copyright, which is an automatic right that exists in anything that's committed to writing. It can be know-how, it can be database rights, it can be unregistered trademarks or design rights. If you aren't aware of what intellectual property exists in your business, it might be wise to consider an intellectual property audit. Lawyers such as ourselves can carry these out, and there are also other experts out there in the marketplace that can carry them out for you. But an IP audit is a really good way of assessing what IP exists in your business, what value is attributable to that IP, and in what ways that IP can be protected better and exploited to a certain extent. So have some thought to having an IP audit carried out, particularly if IP is prominent in your business, and that would include businesses such as tech companies, manufacturing companies that are generating innovative processes, pharmaceutical businesses, businesses that are coming up with new processes or inventions for ways of doing things. Once you've had the IP audit carried out, or before it, as long as you are aware of what IP exists in your business, consider if you've protected the IP. So, for example, if you have a logo or a brand that has got a lot of goodwill invested in it, then consider registering it as a trademark with the trademark registry. You may want to consider having inventions or innovative processes patented. This can be a long and cumbersome process, but it can also give you a competitive edge, so it's something worth considering. If you don't know what can be protected, again, look at taking some advice. And in relation to know-how, this is a really key area that is often overlooked by a lot of businesses. Make sure that know-how, which is critical to the operation of your business, is properly recorded in writing. Make sure that you have processes in place for recording that know-how. There are so many companies that I come across that just simply rely on key members of staff to use the IP properly, the know-how that they have, and they leave that know-how sitting in the heads of those employees. Any buyer will want to ensure that that know-how is recorded in writing, so that if key members of staff were to leave a business either before or after a business has been sold, at least the buyer will have the tools there it needs to continue the business and to use that know-how. So absolutely make sure that know-how is committed to writing, and if that is a long process that needs to be done over a period of time, then start it well in advance of any plans to sell the business. Also make sure you put copyright notices on things that are recorded in writing, particularly anything that is important to your business. Copyright is an automatic right that exists automatically as soon as something's been committed to writing, but if it's key documents relevant to your business, it's always worth popping a copyright notice on there. A point to note in relation to employees and intellectual property is that provided an employee is creating intellectual property rights in the course of their employment and are doing so as part of their employment, the intellectual property rights in what they create will belong to your business. So, if something is committed to writing by an employee, provided they're doing it in the course of their employment, the copyright in that piece of writing will belong to your business, and so on. It's always beneficial to make sure you've got fairly robust intellectual property provisions in employee contracts. That might be something you want to consider in the future as part of this process, particularly for members of staff who are engaged in innovation and development areas. However, one area that is often overlooked, and this is the third point we want to talk about, is intellectual property and external contractors. Many businesses engage external contractors and consultants as part of their business. It's cost effective to do so, and it comes with many advantages, particularly when a business is starting out. However, you need to be aware that if you are engaging contractors to create something that will be used in your business, that the intellectual property rights in what that contractor creates for you will belong to the contractor. It will not automatically belong to your business. Irrespective of whether you've paid the contractor to do that work, the IP rights in whatever they create for you will belong to the contractor. The only way you can change this is by making sure that you have a written contract in place with that contractor or that consultant, and that in that written contract there is an assignment of all the intellectual property rights in whatever they create for you being assigned to your business. It is absolutely key that this is done. I work with a lot of businesses, in particularly software development companies, who have used developers who are not employees, they are contractors, to develop key pieces of software and code for their businesses in the early days, and they have not had an agreement in place with those contractors. A lot of them are friends and former work colleagues, and they've got great relationships with them, and that's brilliant. However, a buyer will want to see that those rights have been properly assigned and are owned by the business. If that is not the case, that will erode a sale price. So please make sure now, if you have any contractors that you've used previously and you haven't had contracts written in place with them where you have assigned the intellectual property rights that in the deliverables they created for you to the business, that you get those contracts in place now. It can be done. It's not a hugely expensive exercise, but it's better to have those contracts in place well in advance of any sale rather than trying to address them when you get to a sale situation. So in relation to intellectual property, what you need to think about in your checklist for any potential sale preparation, you need to be thinking about what intellectual property exists in your business. If you don't know, or it's not easy to identify what IP exists. Consider having an intellectual property audit carried out by a professional. As part of that IP audit, recommendations will be made as to what intellectual property can be registered and what you can do to further enhance the value of that intellectual property. You need to register key intellectual property if you've not already done so. You need to consider putting copyright notices on any key documents that exist in your business. In relation to know-how, you need to ensure that you have proper processes for recording key know-how relevant to the operation of your business, and to ensure that that know-how is written down and not left in the heads of any employees. If you are engaging contractors or consultants, or you have done so in the past, please make sure that you've had contracts in writing with those contractors and consultants, and importantly, those contracts contain an assignment of any intellectual property rights in the items they've created for you, assigning those rights to your business. They can be done now and can apply to works that have been prepared in the past, but it just is important that the matter is addressed sooner rather than later. And also consider having a good non-disclosure agreement in place. All businesses should have a standard non-disclosure agreement, which is also referred to as a confidentiality agreement, in its records, which it can sign up to with anybody it's having potential discussions with for business opportunities. And that's another good way of protecting any intellectual property rights that you may have, which you may need to disclose as part of any business discussions. So, moving on to our fourth topic, this is supplier contracts. Again, supplier contracts are a key area that would be pored over by a buyer of any business, because they need to ensure that key supplier contracts will remain in place post-sale and that they can rely on those suppliers such that the operation of the business is not interrupted due to the sale process. So first of all, consider whether you've got standard terms and conditions of purchase. Have you got these in place? Are they properly drafted? Have they been drafted for you? Are they up to date? Are they relevant? Do they cover all the applicable laws that have been implemented? It's really important to have some standard terms and conditions of purchase because, again, it enables you to remain in control of the buying process when you're dealing with suppliers. You also need to consider whether you have a proper process in place for implementing those standard terms and conditions of purchase. Have your staff been properly trained? Do your staff know when to send out the standard T's and C's of purchase? Do they know how to ensure that those standard terms of purchase apply over and above any that a supplier may seek to impose on you? We can always assist you with preparing those standard terms and conditions of purchase and providing training to your staff on implementation of those T's and C's. So again, consider having those in place and whether you need to get some prepared for you. And then moving on to key supplier contracts. You need to have in your mind exactly who your key suppliers are. A list of key suppliers is absolutely critical and any buyer will ask you to supply those. They'll also want to check the creditworthiness of those suppliers. So again, we recommend that you carry out regular credit checks on your suppliers to ensure that they are creditworthy and that there is nothing that might impact on them or cause them to go into liquidation or administration. Have the contracts that you've got with your suppliers been committed to writing? Have you got written contracts in place? And more importantly, are the contracts up to date and are the commercial terms in those contracts accurate and reflect what you have agreed with your suppliers? Again, exclusivity, fixed duration, volume discounts, pricing, all key areas that need to be addressed in the contract and should be properly reflected in any contract you've got with your suppliers. And as we discussed earlier in relation to customer contracts, we want to avoid any provisions that would trigger termination of those contracts on the change of control. Any buyer will be poring over those supplier contracts to see if there is a change of control clause in them. and also if those contracts can be assigned to the buyer without permission from the supplier. So your checklist for your supplier contracts are as follows. Consider who your key suppliers are. Put a list of key suppliers in writing. Have you got written contracts in place with all of those key suppliers? What are the key commercial terms that you've agreed with those suppliers? And more importantly, have those terms been reflected in the contract? Also consider if you've got standard terms and conditions of purchase, when they were last reviewed, and what processes have you got in place with your purchasing staff for agreeing contracts with suppliers, and do you need to consider any additional training for your purchasing staff? So the final area that I wanted to touch upon, which is becoming ever more prominent in due diligence inquiries by buyers, is data protection. Most businesses process personal data. A lot of people think that being a data controller only applies if you're processing customer data, and some translate this even more narrowly, thinking that it only relates to customer data that they receive online. Personal data refers to data, not only customer data, but your employees' data as well. So most businesses with employees will be processing personal data, and as such should be registered with the Information Commissioner's Office as a data controller. There's really no excuse for not registering as a data controller with the ICO. It's very easy to do. You can do it online, and it's relatively cheap. From last check, it was £35 a year to register as a data controller. So it really is something that can easily be done and should be done if you are processing personal data within your organisation. You also need to consider if you've got anybody allocated with responsibility for data protection and compliance in your business. Really, there should be somebody within your business who has received at least basic training on what the obligations are for protecting personal data and for keeping that data secure, and to ensure that you can comply with the Data Protection Act and the other data protection legislation. And as part of that whole process, you need to consider what data you process. So again, you might need to engage someone to carry out a data protection audit for you and a data security audit. There are data security specialists out there that can do this for you, but you need to go down to a very basic level and consider what personal data you collect in terms of your employees and in terms of your customers, especially if you're dealing with consumers. And then you need to consider what processes you have in place for keeping that data secure. Do you encrypt databases? Do you ensure that any personal data that is transferred via email is encrypted? Are there password protections on all computers that store data? Is data backed up on a regular basis? Is it stored in the cloud? If so, what are the data backup processes in place for storing it in the cloud? And what are your disaster recovery processes? Do you record the processes that you follow in writing, for example, in the format of a data security policy? If you are a business that is recording large amounts of data and handling large amounts of personal data, then it is recommended that you should have a data security policy in place. Also consider whether you've got a privacy policy and a cookie policy. Both are relatively basic, straightforward legal documents, and they are incredibly good ways to demonstrate that you comply with the Data Protection Act and the other relevant pieces of data legislation. Neither are expensive documents to get in place, and they can be done relatively quickly. So also consider if you need to have a privacy policy and cookie policy. I would suggest that most companies need to have those policies in place, and to get them in place if you haven't already got them in place. If you are unsure, take advice from the professionals. We're here to help. We can give you pointers, we can give you tips for ensuring that you're compliant, and again, this will prevent any sale price being reduced and enable you to provide robust and thorough replies in any due diligence inquiries from potential buyers. So that concludes the presentation on our 5 top tips. We have got a PDF that we can circulate to anybody who's interested, which outlines what we've discussed and also provides those checklists. But always consider key contracts, whether you're key customer contracts, key supplier contracts and other contracts, and make sure that they're all in writing. Intellectual property rights, be aware of what IP exists in your business, make sure it's protected, and if you do use contractors or consultants, make sure you've got proper agreements in place with them assigning the intellectual property rights. And in terms of data protection, ensure that if you are processing personal data, you're registered as a data controller. Look at getting a cookie and privacy policy in place, and look at the processes you have in place for recording and handling personal data. So I'm just going to stay online for a little bit longer. If anybody's got any questions, now are the time to put those questions to us, and we will we'll deal with them as soon as possible. So we've got a question from Mark Burns as to how much you could lose if you get this wrong. That is a huge question, but it can have an incredibly detrimental effect on a business and the value of a business if you fail to get these things right. If you got everything wrong in terms of the items that I discussed, so you had no contracts written down with your key customers, no written contracts with your suppliers, you didn't comply with data protection legislation, and you failed to protect your intellectual property rights, and you had no contracts in place with contractors, and as such key intellectual property rights were owned by those contractors, you would be looking at a huge reduction in the value of your business. You may even risk a buyer walking away because they would have no certainty as to customers staying with the business post-exit, no certainty as to suppliers being able to keep supplying them. Key intellectual property rights, they may be held to ransom by those contractors who might realise that what they are holding has huge significant value, and you might be facing significant penalties from the Information Commissioner's Office. So all of those things would have a massive impact on the sale price depending on how important those things are. But, you know, your sale price would be slashed, and there is a significant risk that a buyer may walk away. So huge risks there if you don't address these issues. I hope I answered your question, Mark. If anybody's got any other questions, I'm more than happy to address them. I think that we have no further questions. If anybody listening to this after the live webinar has any questions, they are more than welcome to email me directly. My email address will no doubt be circulated by our very capable marketing team, but it is rebecca.kelly@gunnercooke.com. Thank you everybody for attending, and I hope that those who listen afterwards get what they need out of this, as I hope that today's listeners did as well. So thank you very much for your time.